is Michelle Espinoza, Chair of the Real Estate Commission, and I'm going to call the meeting to order. Marcia, will you do roll call?
Joe Chang,
Here.
Graham Kaltenbach,
Here.
Kim Rediker,
Here.
Michelle Espinoza.
Here.
You have a quorum.
All right. Moving on to the approval of the December 7th Real Estate Commission meeting. May I get a motion?
I move to approve the minutes of the December 7th, 2021 Colorado Real Estate Commission meeting as presented.
Wonderful. Can I get a second?
I second.
Any further discussion? All in favor?
Aye.
Motion passes. Do we have any public presentation?
If there's anybody from the public that would like to address the commission, if you look at your control panel, you'll see an icon that looks like a hand. If you click that, I will call your name and unmute you. Madam Chair, it does not look like anybody would like to address the commission.
Okay, wonderful. Marcia, I believe we're on to policy matters with the first matter being the selection of vice chair.
So with Carolyn Rogers' resignation, that leaves a vacancy for the vice chair, and you just need to nominate and vote for someone.
Is anybody volunteering as tribute?
If no one else will, I wouldn't mind stepping up as vice chair.
I move for Graham Kaltenbach to be vice chair of the Colorado Real Estate Commission.
Thank you, Kim.
What do you second?
Ooh.
All right. Any discussion? All in favor of Graham becoming vice chair, please single by aye.
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 Any opposed? Well, Grant, you are it. Welcome.
Great.
And then the next item.
So we are on. Perfect. We are on to complaint investigation audits.
Morning, Commissioners. All right, we'll start with investigative matter A. This is audit number X 2020-113. This report is based on a STIP audit opened on November 30th, 2020. The respondent initially stated that he sold his book of business of third-party property management to another local firm. Through various document requests, it was determined that the respondent actually assigned his book of business for no monetary exchange. Ultimately, the respondent was unable to provide all the records verifying the transfer of all the respective rental funds and security deposits as part of the assignment. The respondent provided 3 reconciliations from November 2020 to January 2021, which showed the commingling of broker funds and negative ledger balances in both the rental and security deposit accounts. The rental accounts also showed transfer of third-party property owners through February 2021, which contradicts the respondent's statement that he ceased managing properties in May 2020. The respondent stated that he closed his security deposit trust account, but he was either unwilling or unable to provide updated reconciliations, account closure docs, documents showing correction and payment of all negative ledger balances, and proof of all applicable funds were returned. Multiple transaction files obtained through another audit showed that the respondent did not use proper commission-approved forms and disclosures, did not disclose his license status and conflict of interest on broker-owned and business partner properties, was party to approximately 166 transactions in which he acted as property manager and owner on properties his exclusive agent had a contract to lease. However, an affiliated broker instead represented the tenants as exclusive tenant listing agent for excess fee, which the respondent also received property management setup fee upon lease execution, while the respondent's exclusive agent did not participate in any of these transactions. Possible violations include 12-10-2171I, converting, diverting, commingling funds, 12-10-2171M, violation of any commission rule, 12-10-2171Q, unworthy incompetent practice, 12-10-4034C, failure to use commission-approved forms, Rules 5.9, diversion and conversion prohibited, Rule 5.10, commingling prohibited, Rule 5.14, record-keeping requirements, Rule 6.2, competency, Rule 6.7, duty to disclose conflict of interest, Rule 7.1, attorney-drafted forms. Recommended disciplinary action includes final agency order, public censure, revocation, and a fine of $22,500. And Auditor Todd Geske is here to answer any questions you may have.
Any questions? May I get a motion?
Madam Chair, I move that in complaint number X 2020-113, we impose disciplinary action of final agency order, public censure, revocation, and a fine of $22,500.
We have a second?
I second.
Thank you. Any further discussion? All in favor?
Aye.
Any opposed? Motion passes as presented.
And just as a matter or note, the next three are all related to each other. Actually, the next four will all be related to each other in addition to the one we just heard. So investigative matter B is audit number 2021-15. The respondent was subject to a follow-up audit for a final agency order on remand dated February 2019. The respondent initially stated they did not perform any real estate activity in the past year, but then followed up that they acted as an exclusive tenant listing agent on 166 transactions, exclusively with one other affiliated firm. The affiliation is due to the respondent's brokerage receiving an assignment on the other firm's third-party property management portfolio. In these exclusive tenant listing transactions, the respondent received a success fee averaging around $500 per contract paid by the tenant. However, as part of the assignment, the respondent's associate broker received an exclusive right to lease these same properties. However, she did not participate in any of these transactions. Multiple tenants stated that they were required to complete an exclusive tenant listing agreement with the respondent, although they never had any communication with him during the transaction, and all tenant agent communications and duties were performed by an unlicensed office assistant. Furthermore, it does not appear that the respondent disclosed conflict of interest regarding his relationship with the property owner and the other firm. Neither firm has provided actual proof that the selling firm and property owner has paid commissions for the respective leasing of these properties. Possible violations include 12-10-2171M, violation of any commission rule, 12-10-2171Q, unworthy incompetent practice, 12-10-2171W, dishonest dealing, 12-10-4051C, failure to promote the interests of the tenant, Rule 6.1, broker must not lend their license, Rule 6.7, duty to disclose conflict of interest and license status. Recommended disciplinary action includes final agency order, public censure, revocation, and a fine of $12,500. And Auditor Jay McLean is here to answer any questions you may have.
Thank you. Any questions or discussion?
Madam Chairman,
Hearing none, may I get a motion?
I move in complaint number X 2021-15 that we impose the following disciplinary actions: final agency order, public censure, revocation, and a fine of $12,500.
Thank you, Kim. Do we have a second?
I second.
Thank you, Graham. Any further discussion? All in favor?
Aye.
Aye. Aye.
Any opposed? Motion passes as presented.
Next is investigative matter C. This is audit number X 2021-45. The respondent was audited in relation to corresponding audits of the respondent's associate brokers and brokerage owners, which is audit number X 2021-15 and X 2021-77. The audit identified that the respondent relied heavily on the broker owners for the operation of the brokerage, including property management and leasing activities. The audit found that the respondent delegated supervisory authority to one of these associate and broker owners despite the broker having a final agency order requiring a high level of supervision. In general, the audit found that the respondent was either unfamiliar or unable to answer general questions regarding the brokerage, including the brokerage trust accounting, age unreconciled checks, broker-owned properties, broker-affiliated businesses, subsidiaries, and conflicts of interest, maintenance markups in the brokerage's acquisition and assignment of another firm's third-party property management portfolio. The audit also found that the respondent was not a signer on the brokerage trust accounts prior to July 28, 2021, and the rental trust account does not appear to include the word trust or escrow in the title. Possible violations include 12-10-2171M, violation of any commission rule, 12-10-2171Q, unworthy and incompetent practice, Rules 5.3, accounts in the name of brokerage firm or broker, Rule 6.2, competency, Rule 6.3, employing broker's responsibilities and supervision. Recommended disciplinary action includes final agency order, public censure, a fine of $5,000, a 60-day suspension, coursework in brokerage relationships, coursework in brokerage administration, coursework in property management, and a license downgrade for 2 years. And Auditor Jay McLean is here to answer any questions you may have.
Thank you. Any discussion or questions? Hearing none, may I get a motion?
Madam Chairwoman, in complaint 2021-45, I move that we adopt the disciplinary recommendations of final agency order.
Anybody want to give a motion on the?
Can you hear me?
I can hear you.
Okay. Sorry. Again, I move that we adopt the disciplinary recommendations of final agency order, public censure, fine of $5,000,
Yes.
suspension of 60 days, coursework in brokerage relationships, brokerage administration, property management, and a license downgrade for 2 years.
Thank you. Do we have a second?
I second.
Do we have a second?
I second.
Yeah. Sorry, I have a little bit of a delay on my side. I apologize. Okay, we have a first and a second. Any further discussion? Great. Can I get a motion? Or I'm sorry, all in favor?
Aye.
Are we having trouble? I think we may be having hearing. Is there any opposed? Not hearing any opposed. Motion passes as presented.
Okay. So for the next two, I'm going to...
Can everybody hear me?
Yes, I can hear you. Okay, so for the next two investigative matters, it's the same respondent. So I'm going to present investigative matter D, and then I'm also going to present investigative matter P out of order. So my apologies for that, but and also the discipline is going to be combined on these. So I'll read the narrative and the violations for each respective complaint matter. For investigative matter D, the respondent was audited in relation to corresponding audits of the respondent's employing broker, which is audit number X 2021-45, and associate brokers and firm owners, audit number X 2021-15. The respondent was subject to a final agency order in September 2018 that included a 2-year license downgrade. The audit found that the respondent was delegated supervisory authority for all leasing and property management functions of the firm despite the respondent's discipline. The respondent's delegated supervisory authority for all leasing and property management functions was updated in May 2020, and also prior to the respondent's completion of the stipulation terms. The respondent is part owner of her firm, and in general, the respondent's employing broker was unfamiliar with the operations of the firm and relied heavily on the broker owners for the day-to-day functions. The firm acquired an assignment of another firm's third-party property management portfolio, and the respondent's exclusive right to lease the associated firm's broker-owned properties. The corresponding audit number 2021-15, found that an associate broker owner entered into 166 exclusive tenant listing transactions in which the tenants were responsible for paying a success fee averaging $500 per transaction, while the respondent had an exclusive right to lease contract for these properties to earn a 3% commission from the property owner. The respondent did not execute any of these leases and was not involved in any of these transactions despite an active exclusive right to lease. A random sample of the tenants stated their only contact with the respondent's firm regarding rental terms was with an unlicensed office assistant. Furthermore, the respondent's rental trust accounts does not appear to be labeled properly, and documentation was provided showing that the employing broker was not a signer on the account until only recently. The firm's through reconciliations appear to have removed all negative ledger balances in broker owner accounts. Possible violations include 12-10-2171M, violation of any commission rule, 12-10-2171Q, unworthy and incompetent practice, 12-10-2171W, dishonest dealing, 12-10-4041, single agent duties, Rule 6.2, competency. And investigative matter P is complaint number 2021-1164. On July 12, 2021, the complainant filed a complaint against the respondent for failure to adequately represent her for property management services. The complainant stated the respondent didn't notify her when the respondent's brokerage required the property management agreement from another brokerage, that the respondent didn't provide the brokerage relationship disclosures, that the respondent didn't offer advice or guidance with pandemic rental assistance programs, that the respondent didn't disclose conflicts of interest regarding the respondent's ownership in the brokerage and brokerage maintenance company, that the respondent didn't perform required landscaping maintenance on the property yet billed the complainant for the work, and that the respondent paid expenses to the brokerage maintenance company from the complainant's security deposit without her approval or acknowledgement. The investigation found that the respondent provided the complainant with a generic introduction letter that was not personally addressed to the complainant, introducing the respondent as the complainant's new landlord agent. However, the respondent did not provide the complainant with any new brokerage relationships, property management agreements, or disclosures of the respondent's ownership interest in the brokerage or brokerage maintenance company. The property management agreement in place from the previous brokerage lists the relationship as a transaction broker. The respondent's brokerage maintenance company did bill the complainant, which was paid out of the complainant's security deposit without approval and in dispute of the work actually being performed. Shortly after receiving the complaint, the respondent did refund the complainant. Possible violations include 12-10-2171I, converting, diverting, commingling funds, 12-10-2171M, violation of any commission rule, 12-10-2171Q, unworthy and incompetent practice, 12-10-4041, single agent duties, Rules 5.9, diversion, conversion prohibited, Rule 6.5, brokerage relationship disclosures in writing, Rule 6.17, duty to disclose conflict of interest and license status. Recommended disciplinary action includes final agency order, public censure, revocation, a fine of $25,000, and again, these matters are combined. So investigative matter D and investigative matter P, the discipline would be combined together. And again, Auditor Jay McLean is here to answer any questions you may have.
Thank you. Any discussion?
I don't have any questions. I do just have a comment. I want to commend the investigators on these two matters plus the three before it. This was quite a tangled web, it seems, and they did a really great job of ferreting out all of the issues, made it clear for us to understand exactly what happened in these cases. And with that comment, I would move in matter 2021-79 and matter 2021-1164 that we adopt the disciplinary recommendations of final agency order, public censure, revocation, and a fine of $25,000.
Thank you, Kim. Do we have a second?
Commissioner Rediker, before we get the second, I think this matter is 77, not 79. Eddie, is that correct?
Yes, that is correct.
Would you
My
mind amending? You could just state that you amend your motion to correct the case number.
I amend my motion to correct the case number to 2021-77.
Thank you. Is there a second to the amended motion?
I second.
Thank you, Grant. Any further discussion? Hearing none, all in favor?
Aye.
Aye.
Any opposed? Motion passes as presented. I believe we're on to complaint number 2021-126. Do we have someone presenting
My apologies.
case?
Good morning.
Good morning.
The next is matter F 2021-405. Complainant, who's an associate broker, alleged that the respondent used her advertising listing verbiage and photos in the respondent's listing of a neighboring property. Possible violations include 1210-217-1M, violation of any commission or rule part 4, and rule 6.10 advertising. Disciplinary recommendations include coursework and ethics, diversion, and a fine of $500. And Investigator Gabarty can answer any questions that you may have.
Thank you. Do we have any discussion?
Commissioners, just to clarify,
Hearing none.
we skipped matter E. We'll come back and take that out of order. That was Eddie's case, so we're on matter F now.
Thank you. Any questions? Hearing none, I give a motion.
Madam Chair, in complaint 2021-405, I move that we accept staff's disciplinary recommendations of a coursework in ethics, a diversion, and a fine of $500.
Second.
Thank you, Graham. Any, do we have a second?
Second.
Thank you. Any further discussion? All in favor?
Aye.
Any opposed? Motion passes as presented.
Okay, the next is matter G. complaint number 2021-361. The complainant, who is also a real estate broker, represented himself in the listing and sale of his property. The respondent represented the buyer, who is also her husband, in the attempted purchase of the property. The complaint alleged that the respondent gave out the lockbox code to a contractor without authority. The investigation found that the complainant provided the lockbox code directly to the buyer, who then provided the lockbox code to his contractor. The contractor provided the lockbox code to his employee, who stayed in the property for an unknown amount of time. The investigation found that the respondent failed to execute the exclusive right to buy prior to submitting the contract to buy and sell on behalf of the buyer. Possible violations include 1210-217-1Q, unworthy incompetent practice, 1210-217-1M, violation of any commission rule or part 4. The rule should be 6.16. It was entered incorrectly on your copy. 6.16, access to information, broker prohibited from sharing without prior authorization. And disciplinary recommendations include coursework in ethics and diversion. And Investigator Gabardi can answer any questions.
Any questions or comments on this case?
I do have one question. Are these recommendations, are they in line with what we've done in the past? I mean, is it making a difference that, this is the sale of his own property versus I had a listing a couple years ago where, the buyer's agent gave out my listing's lockbox code. And, my buyer, my seller came home and, the buyer himself was standing in the condo. And that just seemed, quite, my seller was not too happy. I'm wondering if this is something where, maybe a little bit more is, kind of justified here. I'd like to hear, just some discussion, being, we haven't seen this before. I'd like to hear a little bit about that.
Penny might be able to speak more towards what we've done historically.
This is consistent with the exception of a fine, and I don't know if Marcia wants to speak to that.
Well, so I had sent you an email about some of the budget issues that we've had, and the need to cut back on revenue. So in lieu of a fine, we have been recommending additional coursework. This one is a little different because you have the actual listing agent giving out the lockbox combination to somebody rather than like the buyer's broker just giving it out. So I think that's a different fact pattern, but still.
Okay, yeah, I mean,
rule violation.
I mean, that clarifies things for me. I just wanted to see. Thank you.
All right. May we get a motion on this case?
I motion in complaint 2021-361 to accept the disciplinary recommendation of diversion and a coursework in ethics.
Great, thank you. May I have a second?
I second.
Any further discussion? All in favor?
Aye.
And opposed? Motion passes as presented.
Okay, the next is matter H, complaint number 2021-2115. On November 5th of 2020.
Nicole, before you go into that, can we go back to E and take care of that one first, please?
Sure.
Sorry, Nicole, Commissioners. Okay, investigative matter E, this is complaint number 2021-362. 2021-1926. On October 13, 2021, the respondent was convicted of violation of protection order, criminal, and violation of protection order civil, class 1, class 2 misdemeanors, respectively. The respondent was sentenced to 2 years supervised probation, as well as 60 days in jail, 50 days suspended upon successful completion of probation. The sentence runs concurrent with different criminal conviction in case the respondent's probation is ongoing. Possible violations include 12-10-2171M, conviction plea specified crimes. Recommended disciplinary action includes diversion, and probation will run concurrent with the respondent's criminal sentence, and coursework in ethics. And I can answer any questions you may have.
Thank you. Any questions? Hearing none, may I get a motion?
In complaint 2021-1926, I move that we accept staff's disciplinary recommendations of diversion, probation concurrent with the criminal sentence, and coursework in ethics.
Thank you, Kim. Can I get a second?
I second.
Thank you. Any further discussion? All in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Okay,
We'll
we're back
leave
to
for on to
We're back to matter H, complaint number 2021-2115. On November 5th of 2021, the respondent pled guilty to misdemeanor 2, violation of protection order civil. He was sentenced to 6 months supervised probation and anger management education, which will be deferred upon successful completion on May 5th of 2022. His court costs and fines in the amount of $539.50 have been paid in full. Possible violations include 1210-217-1M, violation of any commission rule or part 4, 1210-217-1N, conviction, plea to specified crimes, 1210-217-1P, failure to immediately notify CREC, and Rule 6.23, immediate notification of conviction. Disciplinary recommendations include a final agency order, public censure, a fine of $500, and a direct referral to the AGs.
Thank you. Do we have any questions or comments? Hearing none, may I get a motion?
In regards to complaint number 2021-2115, I move that we accept the disciplinary recommendations of final agency order, public censure, fine of $500, and a direct referral to the Attorney General.
Second.
Thank you. Any further discussion? All in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Okay, the next is matter I, complaint number 2021-581. The complainant alleged that the respondent had listed a property for sale without an active real estate license. The respondent acknowledged to the investigator that she only worked one transaction during the time her license was inactive. However, her employing broker provided transaction files for 5 properties that the respondent worked during the time her license was inactive. Possible violations include 1210-217-1M, violation of any commission rule, 1210-217-1Q, unworthy and incompetent practice, Rule 6.26, actions when license is suspended, revoked, expired, or inactive, and disciplinary recommendations include final agency order, public censure, coursework in ethics and legal issues of 12 hours, and coursework in contracts. And Investigator Peters is here if you need to ask him any questions.
Thank you. Questions or comments?
With this one, I do question whether public censure is warranted or necessary, and I just wanted to open that for discussion. Again, I don't know if that's just what the disciplinary action has been in the past. I just don't feel like the respondent did it maliciously. But I understand that she did practice without a license, and I believe E&O insurance. So I'm a little on the fence with that.
I am a little conflicted on that as well. So I'd just like to have a little balance there before we vote. Well,
I think the reason that we recommended public censure was because it was a total of 5 transactions in a smaller community. And again, the consumer was not aware that she was not covered by errors and omissions insurance for those 5 transactions.
She had no prior stipulations, correct?
Correct.
I would motion to accept the disciplinary recommendations except for removing the public censure. And I can do that formally if...
Yeah, so is that a formal motion, Joe?
Yeah, and in complaint 2021-581, I motion to accept disciplinary recommendations of final agency order, coursework and ethics and legal issues, and contracts, but remove public censure.
Do we have a second?
I second.
Thank you, Graham. Any further discussion? Hearing none, all in favor?
Aye.
Any opposed? Motion passes with final agency order, ethics and legal issues, 12 hours, coursework in contracts.
Okay, the next matter is matter J. That's complaint number 2021-53. The complainant alleges that the respondent sent the complainant's father an unsolicited offer in the form of a contract to buy and sell, with the respondent shown as the listing agent to be paid by seller, even though neither the complainant nor her father had a brokerage relationship with the respondent. Possible violations are 1210-217-1Q, 1210-217-1M, 1210-408-2B, Rule 6.5A. Disciplinary recommendation is diversion and coursework in contracts, coursework in brokerage relationship, and coursework in ethics. And Investigator REC is here to answer any questions you may have.
Thank you. Do we have any questions or concerns about this case? Hearing none, may I get a motion?
And complaint. Go ahead.
Okay. In regard to complaint number 2021-53, I move that we accept staff's disciplinary recommendations of diversion, coursework and contracts, brokerage relationships, and ethics.
Second.
Thank you. Any further discussion? Motion passes as presented.
Aye.
Moving on to investigative matter K.
Hold on, Eddie. sorry, I didn't hear the commissioners vote on that one.
Did I miss the vote? Whew. I'm sorry. All in favor?
Aye.
Any opposed? Motion passes as presented. Sorry.
All right. Investigative matter K is audit number X 2021-113. The respondent submitted responses to a routine audit that indicated that he only had one established trust account holding both security deposits and rents. Additionally, the respondent indicated he was not obtaining the broker's disclosure to tenant in advance of receiving confidential information from tenants. During the course of the audit, the respondent opened an additional trust account and has since segregated rental proceeds from security deposits as well as provided compliant three-way reconciliations for both accounts. Lastly, the broker has affirmed that moving forward, he will obtain the broker disclosure to tenant at or before the time of application. Possible violations include 12-10-2171M, violation of any commission rule, Rules 5.5, trust or escrow account required for rental receipts and security deposits, Rule 6.5, brokerage relationship disclosures in writing. Recommended disciplinary action includes diversion, coursework and trust accounts, and Auditor Betsy Meredith is here to answer any questions you may have.
Good morning.
Good morning. Any questions or comments for Betsy? Hearing none, may I get a motion?
In complaint 2021-113, I move that we adopt staff's disciplinary recommendations of diversion and coursework in trust accounts.
You have a second?
Second.
Thank you, Joe. Any further discussion? All in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
The next item is investigative matter L. This is audit number X 2021-130. This audit was conducted in accordance with the stipulation for diversion the respondent signed on February 5th, 2021 in relation to a previous audit that identified deficiencies in trust account. Although the broker has corrected some of the previously identified violations, there appear to be ongoing issues with the broker's trust account. The broker stated that she has not been consistently performing proper three-way reconciliations of the rental trust account, and she was unable to explain why the account contained approximately $12,000 in funds labeled holding for rent online checks, or who these funds belong to. Additionally, it appears she may not be obtaining the broker's disclosure to tenant prior to receiving confidential information. Possible violations include 12-10-2171H, failure to account for funds received, 12-10-2171I, converting diverting commingled funds, 12-10-2171M, violation of any commission rule, Rule 5.10, commingling prohibited, Rule 5.14, record-keeping requirements, Rule 6.5, brokerage relationship disclosures in writing. Recommended disciplinary action includes final agency order, public censure, coursework and trust accounts, coursework and property management, coursework and legal issues, and a follow-up audit within 3 months. And again, Auditor Betsy Meredith is here to answer any questions you may have.
Thank you. Do we have any questions or comments on this one? Hearing none, may I get a motion?
In complaint 2021-130, I move that we adopt the disciplinary recommendations of staff of final agency order, public censure, a follow-up audit within 3 months, coursework and trust accounts, coursework and property management, and coursework and legal issues.
And the follow-up audit within 3 months?
I said that before the coursework, yes.
Oh, yep. May I get a second?
I second.
Any further discussion? All in favor?
Aye. Aye.
Any opposed? Motion passes as presented.
Commissioners, before we move on to the next matter, this case number is X 2021-130. The audit matters, I think, are given a special designation in the division's reporting system. So if you could just note that if you're making a motion, if you call out the specific case number. Thanks much.
All right. Next investigative matter is investigative matter M. This is audit X 2021-111. This was a routine audit opened on October 15, 2021. The audit identified deficiencies in the trust account record keeping requirements, specifically a lack of performing monthly period reconciliations. Additionally, trust account records indicate that multiple properties contain negative ledger balances. Possible violations include 12-10-2171I, converting, diverting, commingling funds, 12-10-2171M, violation of any commission rule, Rules 5.9, diversion conversion is prohibited, Rule 5.14, record keeping requirements. Recommended disciplinary action includes diversion, coursework in trust accounts, coursework in property management, coursework in legal issues and risk, and follow-up audit within 3 months. Auditor Todd Geske is here to answer any questions you may have.
Thank you. Do we have any questions for Todd? Can you get a motion?
In regard to complaint number X 2021-111, I move that we accept staff disciplinary recommendations of diversion, coursework in trust accounts, property management, legal issues and risk, and a follow-up audit with 3 months.
Can you get a second?
Second.
You can. Any further discussion? Hearing none.
I guess I'm
go ahead.
confused because Angela said it was 2021-130.
Oh,
So I
okay.
just,
Okay.
maybe we just say in commission matter M.
So, Commissioners, because the discussion on the record is about this matter, you don't need to call out the case number at all. I was just mentioning that for audit matters, there's an X in front of the 2021, and Graham did read that as part of his motion. So if you are going to read the case number, just be sure that you read it exactly as it's written on the referral. Thank you.
Right. In the previous investigative matter, L was X 2021-130. So M, it should be correct at X 2021-111.
Perfect. So I think we were all in favor.
Aye.
Aye.
Any opposed? Motion passes as presented.
Our next matter is investigative matter N. This is complaint number 2021-456. On April 2nd, 2021, the complainant filed complaint number 2021-456 against the respondent, stating that the complainant represented the buyers that put an offer on a vacant land that the respondent had listed for sale. The complainant stated the respondent failed to disclose he had ownership in the land. The buyers and the complainant became aware that the respondent's ownership interest in the property when the respondent signed the contract as the managing broker of the selling entity. The complainant stated the respondent failed to amend the contract when he became aware the name of the seller was not correct. The investigation noted that the respondent signed both the contract buy and sell and amend with the wrong seller name. Once the buyers terminated the contract and requested the release of their earnest money, the respondent delayed the signing due to not having the correct seller name. The respondent ultimately crossed out the seller name and hand wrote correct seller name. Possible violations include 12-10-2171M, violation of any commission rule, 12-10-2171Q, unworthy and incompetent practice, 12-10-2171W, dishonest dealing, Rule 6.17, duty to disclose conflict of interest, license status. Recommended disciplinary action includes final agency order, public censure, coursework in contracts, coursework in ethics, coursework in legal issues. And Investigator Marcy Rivera is here to answer any questions you may have.
Great. Thank you. Any questions for Marcy? Hearing none, may I get a motion?
Madam Chairwoman, in Commission Matter N, I move that we adopt the disciplinary recommendations of staff of final agency order, public censure, coursework in contracts, coursework in ethics, and coursework in legal issues.
Thank you. May I have a second?
A second?
Thank you, Joe. Any further discussion? All in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
And your final investigative matter for the day is investigative matter O. This is complaint number 2021-828. On May 24, 2021, the complainant filed complaint number 2021-828 against the respondent, stating that the respondent entered into an exclusive right to buy contract as a buyer's agent. The complainant stated the respondent failed to protect his interests and contacted his employer directly without permission from the complainant. The complainant stated the respondent also disclosed to the listing agent his financial situation without permission. The complainant stated he terminated the contract, but the seller refused to release the earnest money. The respondent acknowledged that he had contacted the buyer's employer directly in hopes of saving the earnest money. The respondent acknowledged he informed the listing agent that the complainant was no longer employed. Contract terminated in May 2021. The seller did not sign the release of earnest money until September 2021. Possible violations include 12-10-2171Q, unworthy incompetent practice, 12-10-405, single agent engaged by buyer. Recommended disciplinary action includes diversion, coursework and brokerage relationships, and coursework and issues. And Investigator Marcy Rivera is here to answer any questions you may have.
Thank you. Any questions for Marcy? Hearing none, may I get a motion?
In regard to commission matter O, I move that we accept staff's disciplinary recommendations of diversion, broker and coursework in brokerage relationships and legal issues.
Thank you. Do I have a second? Thank you, Kim. Any further discussion? All in favor?
Aye.
Aye.
Any opposed? Motion passes as presented. I believe we are now.
Yes, licensing matter A is an application, complaint number 2021-2030. The applicant surrendered their Colorado real estate license in January 2019. This was treated as a revocation after the Real Estate Commission voted to revoke in connection with a theft. The applicant received a negative preliminary advisory opinion in June of 2021. On November 12, 2021, the applicant paid the previously stayed real estate fine, Colorado Real Estate Commission fine of $3,450. There is no recommendation, and Investigator Levy is here to answer any questions.
Any discussion on this one? Do we have a motion?
I will be honest and say I have a tough time with this one. I do say that in the at minimum, if we do approve their license, they must downgrade to an associate level. And I would say for 5 years. I know that their license before was an independent, correct? Independent broker.
Yeah, let us look that up. David, do you know?
Yeah, he's an independent.
So Joe, you're wanting supervision if we give back the license for 5 years as an associate broker?
Correct. So I guess I'll motion to approve the applicant with, again, the restriction that they downgrade their license to associate level and be supervised for 5 years.
What do you think about, what do you think about also making it a requirement to notify the current, their employee managing broker of their past
Yes.
history? Would you mind amending your motion to include that?
Sure. I motion to approve the applicant for license with the restriction that they must downgrade their license to an associate level and be supervised for 5 years, and notify their employing broker of their criminal history.
Amended second.
Thank you. Any further discussion? Hearing none. All in favor?
Aye.
Any opposed? Application for licensure is approved with downgraded license associate with high level of supervision for 5 years and notifying their employee managing broker of past discipline.
Okay, licensing matter B is an application. This is complaint number 2021-1594. On March 18th, 1994, the applicant pled guilty to forgery, second degree, a class 4 felony. The applicant was sentenced to 2 years deferred sentence and judgment, probation for 2 years, a fine of $760, and restitution in the amount of $69.40. The applicant currently has a $0 balance. On April 18th, 1995, the applicant pled guilty to theft, a class 4 felony. The applicant was sentenced to 4 years probation, a fine of $1,250, and ordered to pay restitution in the amount of $2,656. The applicant has completed all requirements for probation and has paid the fine and restitution in full, and the case is closed. There's no recommendation, and Tabitha Glenton is here to answer any questions you may have.
Does anybody have any questions for Tabitha?
I don't have any questions. I would like to move in matter B, licensing referral, for a full approval of this application for licensure.
Thank you, Tim. Do we have a second?
A second.
Wonderful. Any further discussion? All in favor?
Aye.
Aye.
Opposed? Motion passes as presented.
Licensing matter C is an application. It's complaint number 2021-1815. On May 15th, 2003, the applicant pled guilty to misdemeanor theft/stealing. The applicant was sentenced to 2 years probation. Probation was revoked and they were resentenced to 30 days home detention in lieu of 55 days in jail. A fine of $474 and 20 hours of community service was also issued. On May 23rd, 2008, the applicant pled guilty to felony conspiracy to distribute and possess with intent to distribute. The applicant was sentenced to 60 months jail, 12 months of probation, and a fine of $100. Probation was revoked and they were resentenced to 10 months in prison and 1 year supervised release. The applicant completed all terms, including jail and probation, and the case is closed. There is no recommendation, and Tabitha Quintana is here to answer any questions you may have.
Does anybody have any questions for Tabitha? Hearing none, may I get a motion?
I don't have any questions. I will say that my motion is based upon the time that has passed since the incidents with this applicant, and also the number of recommendations and that they presented in their personal statement. And with that said, I move in licensing matter C for a full approval of the license application.
Thank you. Kim, do we have a second?
I second.
Thank you. Any further discussion? All in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Licensing matter D is complaint number 2021-1997. This is an application. On November 26, 2012, the applicant pled guilty to accessory after the fact and misdemeanor. The applicant was sentenced to a 6-month jail sentence that was suspended, and the case is closed. No recommendation, and Tabitha is still here to answer any questions.
Any questions? May I get a motion?
In licensing matter D, I move for full approval of the application for licensure. In licensing,
I second.
Do we have a second? Thank you, Graham. Any further discussion? Hearing none. All in favor?
Aye.
Any opposed? Motion approved as presented.
Licensing matter E is complaint number 2021-2087. This is an application. On November 19, 1999, the applicant pled guilty to criminal attempt to commit theft, a class 5 felony. The applicant was sentenced to 5 years probation, a fine of $721.50, and ordered to pay restitution in the amount of $10,114. The applicant has completed probation successfully, and the fine and restitution is paid in full. The case is closed, and there is no recommendation.
I think that my recommendation, again, also comes down to the time
Any
of.
questions? We have a motion.
Yes. In regard to licensing matter E, I move for a full approval. I think that there has been a considerable amount of time that has passed between, the incidents on the
So
reports.
your motion.
I move for full approval in licensing matter E, if you want me to shorten it.
second.
Thank you. Thank you. Do we have a second? Thank you, Kim. Any further discussion? Hearing none, all in favor?
Aye.
Aye.
Am I cutting out? Can nobody hear me? All in favor? Any opposed? Hearing none, motion passes as presented.
Okay, licensing matter F is an application. This is complaint number 2021-2099.
Are we cutting out?
I think you're just on a delay, Michelle.
Yeah, Michelle, you keep cutting people off when they're talking, so I don't know if you just want to give them like a minute or two to see if they talk and then go.
Okay.
All right, so complaint number 2021-2099, matter F.
Okay.
On February 6, 2006, the applicant pled guilty to violent crime, used weapon, theft of $500 to $15,000, a class 4 felony, and robbery, aggravated menace, victim with deadly weapon, a class 3 felony. The applicant currently owes a balance of $25,212, and the case is closed. On May 2nd, 2019, the applicant pled guilty to a class 1 drug misdemeanor, controlled substance, possession of Schedule 345. The applicant was sentenced to 18 months probation and a fine of $2,308, a current balance of $2,243.50. The applicant has completed probation successfully. The case is closed, and there is no recommendation.
A discussion?
So I'm inclined to approve this application. My only concern, and I'd love to hear from the other commissioners, is in the broker's letter, it talks about how they're aware of the misdemeanor charge, but they do not note their awareness of the other charges. So I think, and again, before I make a motion, I'd love to hear from everyone else. I would like to have acknowledgement from the broker that they're aware of the complete background of the applicant. I don't know if we can require that, though.
I mean, do we know that offhand? If it just, if they don't, I mean, in the investigation that's done, was that something that came up?
We asked them to notify the broker of their background.
But you are right, in that letter, it does only speak the misdemeanor.
I mean, I would agree with making that, a requirement as well. And I think, with some, extended period time of, supervised, expert supervision.
Yeah, I mean, it was a long time ago, and the applicant was a juvenile, and so I am inclined to give them this opportunity to work as a real estate agent in Colorado. But I would move in licensing matter F for approval of the license with the condition that the broker or employing broker must be notified of all past convictions, and also with a high level of supervision for 2 years.
Do we have a second?
A second.
Do we have a second?
A second.
Thank you. Any further discussion? I don't know why all of a sudden nobody can hear me. We have a first and a second. All in favor?
Aye.
Aye.
How about that?
Since Michelle is having some audio issues, Commissioner Kaltenbach, would you like to take over and serve as
Motion
vice chair for the
passes.
last matter on the agenda?
Sure. Next up, we have complaint licensing matter. And
Sorry, the team lead will introduce the matter, and then you can just do what Michelle is doing and ask for motions and just oversee the vote. Madam Chair, is that okay with you? Thank you.
Okay, so licensing matter G is an application. It's complaint number 2021-2098. The applicant had 3 criminal convictions in 2012, 2013, and 2014. All records have been sealed. The applicant has submitted a written personal statement along with a recommendation letter, and also submitted a letter the defendant wrote to the court in 2015. As long as, and we also exhibited their application that were all available to the commission. There is no recommendation, and Tabitha Quinton is here to answer any questions.
okay.
And commissioners, sorry, Graham, if it's helpful, the rehabilitation statute does address sealed criminal convictions and specifically instructs that you can't rely on those to support an adverse decision. So for what that's worth, you're being informed of the sealed convictions, but there is a limit to their usefulness to you.
All right, seeing none, do we have a motion?
In licensing matter G, I move for full approval.
Is there a second?
A second.
Okay, is there any further discussion? Okay, seeing none, let's move to a vote. All those in favor?
Aye.
Any opposed? Okay, the motion passes.
Nice job, Graham.
Thank you.
Commissioners, you don't have any other items on your agenda for today. So unless you've thought of something that you would like added to your next meeting agenda,
We are officially done. I don't know if anybody can hear me.
you can go ahead and make a motion to adjourn.
I move to adjourn.
I second.
Well, happy New Year, everybody, and thank you.